Wine Industry Network's 2024 Bold Prediction Series is presented by Heffernan Insurance Brokers, with supporting sponsors Protea Financial, Turntine Brokerage, and American Ag Credit. Thank you for your support.
Hi, Liz Bishop
and Deborah Costa
here from Heffernan Insurance Brokers, and we are your fire mitigation and insurance
gurus.
This wildfire structure protection unit is a unit that the British Columbia government has been utilizing for about 10 years. And in 2023, there were 500 structures that were saved by this unit. So it has proof of concept.
Here today, we have Adam Iveson from Ember Defense to share with you a few important notes about this structure.
So this is a structure protection unit. This has everything on board to be self-sufficient. This has pumps, sprinklers, hose lays, bladders, everything to be off the grid to protect your property ahead of an oncoming wildfire.
Liz and I, in partnership with Ember Defense, are committed to protecting your winery property. Just think, if everyone invested in a wildfire protection unit, together we could ensure that wineries don't burn and make insurance affordable again. Text WASP Demo to 707-789-3062 for a free demo on your property.
Thank you for joining us for this spring edition of our Bold Prediction series. Today we'll have multiple sections, but before we start with this first one, a quick note that if you guys are wanting to participate in the conversation, you can participate by putting questions in over here in the chat, and our speakers throughout the day will be able to answer your questions in the live chat simultaneously, so you don't have to wait till afterward. They are watching along with you during these presentations, which are pre-recorded. So now with that, let me introduce you our first speaker today, John Trinidad. He's the managing partner at Dickinson, Piedmont and Fogarty, and he's going to talk to us about trade practices and the enforcements that we've been seeing and some things you might want to keep your eye on to be on the safe side. So John, please take it away.
Thanks, Kim. Appreciate the introduction, and thanks everyone for joining us today. This is a really great series that the network's put on, and I'm really proud to be part of it. So for my presentation, we wanted to discuss some recent actions that we've seen at the federal level related to trade practice regulations and antitrust enforcement. And really, this is the outgrowth of an overall effort by the current administration to promote competition in the wine industry. So let's walk through what I plan to cover today. The first thing that we'll talk about is Executive Order 14036, which is aimed at promoting competition in the American economy. And this has really been the starting point for a review of alcohol beverage regulations overall, but also includes a real focus on how different federal trade practice restrictions either promote or maybe inhibit competition in the overall industry. And so we'll then dive into what federal trade practice restrictions are, tied house restrictions, exclusive outlet prohibitions, commercial bribery prohibitions, and restrictions on consignment sales, and talk about how those are currently under review. And we'll close out the presentation talking about some recent actions by the Federal Trade Commission and their investigation of the wholesale tier, and specifically Southern Glazers, and we'll tie this all up with some recommendations for those of you in the industry on what you should take away from these range of actions. All right, great. Now that we've set the agenda for the rest of this presentation, let me dig in on the first bullet point, Executive Order 14036. During the first half of 2021, the Biden administration issued a new executive order trying to promote competition in the American economy. And in that, the executive order laid out specific industries that they wanted to focus in on, and it included the alcohol beverage industry. And the goal overall for this order was to try to increase competition and provide more choices, better service, and lower prices for consumers. On top of that, though, the executive order really called out how part of their push for increased competition was to create fairer opportunities for small businesses and entrepreneurs and give them an ability to compete in all these various industries. So drilling down on Executive Order 14036, you can see that one of the real goals here was to improve market access for smaller, independent, and new operations. And as part of that, the administration tasked the Treasury Department, where TTB is housed, to coordinate with both the Attorney General, the Department of Justice, and the head of the Federal Trade Commission to prepare a report to give an assessment of the current market structure and conditions for competition. And as part of that, they really wanted to focus in on unlawful trade practices in the industry. This includes any sort of exclusionary, discriminatory, or anti-competitive distribution practices that may hinder smaller and independent businesses or new entrants from having their products distributed. So this was really a focus, really wanted to look at trade practices, really wanted to look at distribution practices as well, and whether that was allowing for competition or potentially inhibiting competition. So with that mandate, the Treasury Department turned around a report in February 2022. And this is the press release. What they talked about here, again, is trying to create a level playing field for small businesses and new marketplace entrants. But they were looking at two different things. One, whether or not the existing laws were being enforced in a manner that promoted competition. And also want to take a look at the existing regulations and try to figure out whether they needed to be modernized and potentially amended. So this is drilling down into those two different parts. Are there certain updates that need to be made to the existing regulations? And again, they kind of focused in on this idea of modernization and taking into account certain changes in the marketplace that arose post adoption of the Federal Alcohol Administration Act, including digital technology. You'll also see here that they really focus in on actions that are often referred to as category management, designing of shelf schematics and offering of related services, primarily by the distribution tier to retailers. In terms of enforcement policies, what the Treasury Department report said is that TTB should take a look at their policies and respond to any sort of complaints that they were under enforcing actions by larger members and potentially focusing too much on actions by smaller members. Again, they focus in on enforcement actions related to category management and tying arrangements. We'll talk about that shortly. And you'll again see that there's a general sense that TTB should examine whether they need to temper their enforcement against entities that lack market power, again, smaller businesses, in the absence of any obvious anti-competitive effect by actions by those smaller players. So takeaway from the Treasury Department report is we're going to look really hard at trade practices, not only at what's on the books, but how it's enforced. And we want to figure out if we need to reshape our enforcement priorities to make sure that we're looking after what the big folks are doing, and maybe not so much on what the smaller folks are doing, unless there is a truly anti-competitive effect. We'll get into that in a minute. So that then begs the question, and I'm sure all of you are asking, what do we mean by federal trade practice regulations? So there are 4 specific practices under the federal laws that are viewed as being creating unfair competition and are unlawful practices. So the FAA Act calls these out, and even though we kind of sometimes think of these as just restraints on actions that a player can take, we've really got to think about that in this presentation in the overall context of the health of the industry and the idea that these specific trade practice regulation areas are meant at their base to promote competition. And that's really kind of the focus here. It's not really so much of just the ill effects of alcohol beverage post-prohibition, but really the idea of creating a healthy marketplace where players can compete on the basis of their goods as opposed to other things. So let's dig into those 4 different areas of trade practice regulation. The first one is exclusive outlet. And this is directly or indirectly requiring a retailer to purchase alcohol from the industry member to the exclusion of others. So the best example here is you have a distributor that approaches a new restaurant and says, hey, why don't we just make an agreement that you are going to purchase all of your wine from my portfolio, and in exchange, I'm going to give you deep discounts on your purchases. So this is the idea that you're creating an exclusive outlet. The restaurant becomes an exclusive outlet of this one distributor's portfolio. And it's not that the retailer is choosing based on the quality of the goods being presented. It's purely just on this idea of creating an exclusive outlet. And that this is viewed as just being a lot of undue influence over the retailer and the wholesaler, the producer tier, really just driving the ship when it comes to retailer purchase decisions. The second area of trade practice restrictions is commercial bribery. And here you're looking at inducing a trade buyer, which could be either a wholesaler or a retailer, to purchase from the industry member and excluding the sale by others by means of commercial bribery or offering or giving any bonus, premium, or compensation to the employees, officers, or representatives of that trade buyer. So example of that is a winery contacting the person in charge of buying wines for a restaurant group and say, hey, why don't I just slide over $500 and you agree to buy my wines. That's commercial bribery at its purest form. The third area is consignment sales. And here, this is basically just selling or offering to sell to a wholesaler or retailer on consignment. So what's viewed as a conditional sale with the privilege of return or any other basis other than a bona fide sale. Now, there are certain returns that are permitted expressly under federal laws and regulations. But in general, if somebody is taking wine from a seller and the buyer is only going to be charged once they sell, then that's a consignment sale. Or if that buyer is able to return, then that's not a bona fide sale, absent one of these express exceptions applying. So we've seen this come about. Wholesaler agrees to only charge a retailer for wine once the retailer actually sells that wine to an end consumer, or a winery and distributor agree that wine will be shipped to wholesaler, but then distributor will only have to pay once distributor has sold that wine. There's this final bullet point here, which is that the other federal trade practice restrictions require a showing of exclusion of others' products. Consignment sales do not require that showing of exclusion. So the bar for proving consignment sale is fairly low. All you have to show is that there was an agreement to ship and not pay, and potentially the agreement to ship and not pay with very loose credit, very extensive credit terms, or even loose obligations by the buyer to actually pay. And this came about in 2017, 2018. There were a lot of investigations by TTB, primarily at small and medium-sized businesses that were engaging in these sorts of operations. And that, I think, may have been some of the backdrop to the Treasury Department's report on trying to figure out, hey, are we really enforcing this against the folks that have the true market power? Or are we just trying to, or are we sweeping into this folks who may be engaged in this conduct, but really don't have any sort of ability to exert extensive market power? And finally, the fourth area of trade practice regulations has to do with tied house. And here we're talking about the direct or indirect inducement of a retailer to purchase alcohol from the producer or wholesaler to the exclusion of others. And there are all sorts of prohibited inducements, and there's all sorts of exclusions. But generally, this is the idea of giving a thing of value to the retailer and getting your product in there, kind of a pay-to-play type scenario. And this pay-to-play can involve either extending very favorable credit terms, providing slotting fees, i.e. actually paying for shelf space, providing a tie-in sale. You buy this, in order to buy product X, you need to buy enough of product Y. And these are just seen as unfair methods of competition. And again, not creating a level playing field for all market participants. So with those 4 pieces of trade practice regulations that are currently in place, TTB issued Notice 216. And a notice is a notice of public rulemaking whereby the TTB invites comments from industry members to opine on a range of different things. And here, this was actually an advanced notice of public rulemaking. So TTB didn't put forth a language in any sort of proposed amendment. They were just trying to request information from the public at large about how they might want to update their trade practice regulations, specifically in how to take into account current marketplace realities, including the rise of digital marketing strategies. That comment period has now closed, but TTB is obviously in the process now of evaluating those different comments and trying to figure out whether any sorts of changes to the regulations or any sort of clarification to how they enforce the regulations would be helpful to the industry and would be helpful to the ultimate goal of the executive order in terms of promoting competition, providing benefits to consumers, and making sure that smaller companies are competing on a level playing field. So interesting to note that there may be some changes here, there may be some additional guidance here, and that this is a moving target. So what else have we seen? So other than the regulation side of things, we've also seen some enforcement actions over the past couple of years. The first notice we received publicly about that was actually through the press, because there was a story in the San Francisco Chronicle that agents of the IRS, as well as TTB, had gone to the offices of Southern to collect material. And while neither of these agencies have provided any sort of public comment in terms of what they are looking at and what they are reviewing or auditing Southern Glazers for, it became the first public news that there may be a review of what's going on at the wholesale tier of the alcohol beverage industry. Now, the IRS and TTB obviously go hand in hand. The alcohol beverage industry is very well versed in dealing with these agencies. So the additional news last year that the Federal Trade Commission was also taking a look at Southern Glazers, I think just goes to emphasize the point that the executive order has teeth. They are following up with enforcement actions in the industries where they wanted to increase competition and conducting a review of what's happening at that distribution tier. So the way that this information came out is that the Federal Trade Commission had issued what's known as a civil investigation demand on Total Wine and More, one of the country's largest wine retailers, asking for information related to Total Wine's relationship with Southern Glazers. Total Wine had viewed the demand as overly broad, and eventually the Federal Trade Commission sued Total Wine in trying to get them to comply with their investigative demand. The lawsuit has since settled, but that lawsuit gave a lot of insight into what exactly the Federal Trade Commission is looking at in regards to Southern Glazers. So let's take a look at that. The Federal Trade Commission is looking at potential violations of the Robinson-Patman Act related to preferential pricing provided by Southern Glazers to certain favored large chain retailers. Now, the Robinson-Patman Act is an act that makes it illegal to discriminate in price between different purchasers of commodities of like grade and quality. And there is some criticism that the FTC's use of the Robinson-Patman Act is a little aggressive. This is an act that has not largely been enforced over a couple of decades, but this is definitely something that FTC has, under the Biden administration, has used in investigating a number of different industries. So it'll be interesting to see how this plays out. In addition to the preferential pricing schemes that that the FTC is looking at, they're also trying to determine whether Southern has provided large retailers with illegal discriminatory non-price services, such as shelf stocking and other forms of free labor and marketing support. Well, that definitely sounds very similar to some of the focus that the Department of Treasury in their report had looked into and directed the TTB to review in terms of shelf stocking, category management type issues. So what we're seeing here is multiple different agencies, IRS, TTB, and now the FTC, really taking a magnifying glass to the distribution tier in the wine and spirits industry and trying to determine whether there's some practices there that would inhibit competition to the detriment of consumers and to the detriment of smaller businesses. So what's the takeaway here, especially for those in the production tier of the alcohol beverage industry? One, it's a good time now to review your distribution agreements to see if there's any provisions that would potentially require you to support anti-competitive practices, category management, buying up a shelf space, etc. So it'd be good to try to look through there, because you don't want to be in a position where you may be indirectly supporting some anti-competitive practices. Two, it's a good time to review your credit terms with both wholesalers and retailers and take a close look and make sure that you are within a safe zone of providing credit terms that are not overly favorable, so that you don't get dinged for either having a consignment sale arrangement or potentially a tied house violation there. There's some recent guidance from TTB on this front that 30 days is generally viewed as a safe harbor on credit terms, but it's worth looking at. On top of that, there are certain states such as Ohio that require cash on delivery, and that would not allow any sort of credit terms for a sale from a California winery, say, to an Ohio distributor. And it's worth taking a close look at your arrangements in states like Ohio that have those restrictions on providing any sort of credit to either wholesale or retail buyers. Three, it's a good time to take a look at your incentive programs. How are you incentivizing your distribution network and their employees, and making sure that those incentive programs are compliant with both federal and applicable state laws. And finally, one final takeaway here is to stay vigilant. This is a moving space. Keep an eye out for any news from the TTB or FTC on how they are looking at trade practices for TTB and for any other anti-competitive behavior on the FTC front, and keep an eye on enforcement actions going forward. So with that, I'll lay things back to Kim.
Thank you, John. That's very interesting activities going on there in the trade space. I did have a couple of questions for you, maybe asking you to put on your crystal ball hat here. But there's some thoughts came up for me. Here recently, we saw that the Justice Department is also taking action against Apple, which is also, of course, a trade practice issue. And this executive order is, 2 years old plus. So it occurred to me, is this a matter of they take some time to build these cases and we might actually see more activities start happening around this time?
Yes, these investigations do take time. And I want to make clear that these things are at an investigation stage. No one's lodged any complaint, formal complaint, any sort of court action against Southern Glazers. But it's because these things take time. The fact that FTC had to felt like it had to sue a non-target of their investigation in order to get information and materials that they think are necessary for them to conduct their review means that things have been delayed a little bit. But the other question that we get a lot, Kim, and I think it's related to what you're asking in terms of a crystal ball, is, well, what happens should we have an administration change in November, and there's a new sheriff in town? The interesting thing about the FTC's actions and the increased amount of antitrust activity at the federal level against multiple different players in multiple different industries is that it has a certain amount of bipartisan support. Just the other day, none other than Matt Gaetz and JD Vance gave a lot of praise to the head of the FTC, saying this is exactly what an agency like the FTC should be doing in order to protect consumers and small businesses. So it's interesting to see that that while there's a lot of animosity amongst the various parties, one potential continuation point here, if there's a new administration, may very well be federal antitrust enforcement.
Another space where I imagine there could be some crossover as well, even in a new administration, would be relief on some regulations if some of those come about with that new notice on the 216 notice. I was wondering, again, with the crystal ball out, do you have any idea of what things might be in there? Maybe there are some trade groups that are advocating for certain things.
It's always well, one, on the trade group front, yes, there was lots of notices, lots of responses to that notice. So lots of input on what should occur at both the trade practice enforcement as well as potential clarifications, modernization of trade practice regulations. It's hard to look with a crystal ball at what will happen. Sometimes there is a knee-jerk reaction that any sort of additional regulation is bad. Sometimes you'll see that there's an effort by agencies not to adopt new regulations, whether that also bleeds into amending regulations or providing an industry guidance on how the agency in charge will be enforcing those regulations is a different question and hard to predict.
Yeah. Some of these rules can be quite opaque to interpret. And I was wondering particularly on the Tide House rules, do you know of any enforcements that are happening on that field, or is that mostly small potatoes?
Currently, I'm not aware of any that are going on at the federal level. Obviously, the news of potential review of what Southern Glazers may be involved in, given the news about the IRS and TTB visitation of their premise, is still up in the air. But obviously, kind of looking at the various Department of Treasury reports and the notice of proposed rulemaking, you would think that category management, shelf schematics are very much within the sweet spot of what the various agencies are looking at. How much are large distributors providing to large retailers to the benefit of those large retailers and potentially to the detriment of smaller retailers out there?
Yeah, and maybe to the detriment of small producers as well.
Correct.
Well, John, thank you very much for your time here. Do you have any closing remarks you want to make before we move on to the next section of our program here?
Thanks, Kim. No, I'll hand things over to the other speakers.
Excellent. Thank you, John. And also another quick thank you to our presenting sponsor, Heffernan Insurance Brokers, and our other sponsors. And with that, I hope you guys are going to join us for the next segment as well. Thanks.